May I please?
Yes.
With consent of my learned brother, my lord, item 21, my lord, maybe taken, my lord, day after tomorrow. In fact, my lord, I lost my brief, my lord. I requested my brother to give me xeroscopy, my lord. I am taking today.
Item number?
21.
Day after tomorrow. Not day after tomorrow, on next Tuesday.
That's probably.
My lord, I beg to mention item 24 on behalf of additional AG, Mr. P.N. Gusau. Today he has some difficulty. Can it be lordship fixed after 2 weeks, lord? Any date?
It may be fixed considering it's a 2014.
Full release from Paternity. Mr. Goswami, we are adjourning this matter only on the ground of Mr. Goswami for last almost how many months? You can see the order sheet.
This one last opportunity may be given.
When? Give a date.
On
No, you have a informed consent from Mr. Goswami and then give a date.
I have been told that lordship it may be fixed the week after the next week, lordship. So 19th or lordship 21st November.
21st of November. The prayer of P.N. Goswami.
Yes. Your lordship.
Yes.
Lordship, I beg to mention item number 15. I'm appearing on behalf of Mr. Z. Alam, lordship, as the senior counsel is out of station. Kindly adjourn the matter for today and fix it after 2 weeks. Lordship.
No, sorry. Prayer rejected. Yes. Next case.
Lordship, I beg to mention item number 12, Mr. B. Chaudhary is out of
Item
station.
number?
12. He's in Shillong, madam. Just inform me about telephone, madam.
Prayer rejected.
Please.
May I please, Your Lordship? I beg to mention item number 39 of hearing list, Your Lordship. This is a 2014 matters, Your Lordship.
Item number?
39 of criminal petition hearing list, Your Lordship.
There is no hearing. There is no hearing list. Hearing list will not come here.
I want that to be taken up in the
2014, that will come. One by one, this will come. Because whatever matters are listed in the hearing is coming from that bench only. Okay, that list only.
Lord.
So sequentially it will come.
Lord.
Okay.
Obliged.
One, what can be in
This case of murder case, Lordship.
Yes,
308
when case there is.
15th of my lord. 15th, madam.
Not 15 is I think holiday. Not on 15. You may fix it on 19th. CD 19th.
It is your lordship. Lordship, can it be taken up after some time, madam? Item number 2, madam.
item number 3?
May I please, Your Lordship?
Yes, it's a second.
My lord, NDPS case, my lord, he was arrested on 3/4/2023, my lord. And since then he is in
3/4.
3/4/2023. Almost 19 months over, my lord. But
What is this? This is scan copies received.
Yes.
Have you gone through it?
Yes, my lord.
Mm,
My lord, earlier rejected. It is on.
rejected, my lord.
My lord. Here the matter is the search sheet dated, my lord.
Charge sheet file when?
Search sheet file 36/2023, my lord.
36 to 20. How many witnesses?
Not a single witness because my lord co-accused he was absconder, my lord. Only 6/9/2024, my lord. He was brought before the court because he was in judicial custody. Thereafter, my lord, next date is 29/2024, my lord.
Who are the how from whose possession it was recovered?
My lord, it is the possession from the petitioner. It is from his house, my lord. Contrabands was recovered, my lord.
Outside, within my campus, my lord. It was recovered from
Mr. Saikya, wait for some time.
Well,
We are not granting at this stage. You withdraw it and come back once, or we are dismissing it right now.
I may be allowed to withdraw.
withdraw it. After some time, let us see what happens. Let at least one witness be examined so far relating to, because they will first produce those witnesses. And if they do not examine any witnesses on next 2-3 days, we'll consider.
Right.
If the trial is delayed because of them, not because of you, then we'll definitely consider. This is one aspect. And other aspect is that if the independent witnesses are examined for relating to possession, if that is nothing, we'll allow you. We are following that standard.
I
Okay,
may be,
Mr. Spencer, learned counsel for the petitioner submits that he may be allowed to withdraw this petition at this stage and to approach this court and or to approach the learned trial court for the time being. Approach once again. To approach this court once again. Full stop. Prayer stands allowed accordingly. This PL application stands closed on withdrawal with a liberty.
Four.
My lord, in item number 4, my lord. My lord, matter may kindly be time being, my lord. My lord, I need some more time, my lord. Go through the
Okay,
NCR, my lord.
okay.
Maybe time being, my lord.
but then move to the.
Okay, when?
Today itself, my lord. Today itself.
Today doubtful. You take it tomorrow or on Monday.
My lord.
Last two occasion I informed.
No, madam, see, please, if we go through all these methods, quashment will start, again will difficult to come back. Okay, go through, we'll see. If time permits, we'll see.
My lord.
Lordship, any other day, Lordship. Any other day.
No, we'll see. Since you have urgency, yes.
Any other day, Lordship.
Yes, next case. Yes, call it. Really matter now. Any idea, no?
Dear Lordship.
Just wait for some time. Wait for some time.
Please, your Lordship.
Yes.
Matter relates to Lordship, 145 proceeding, Lordship, but today morning I have received the instruction that my client expired, Lordship, on 11/7/2024, Lordship.
Now, what any civil suit is pending in
Yes, instruction I have to take, so I request some time, Lordship, at least 2 weeks time, Lordship,
difficult.
then 1 week, Lordship. Over telephone, I try to take instruction.
You have an instruction
Yes.
whether any dispute is pending or not, and anybody is interested, then other agent.
In the statement of the petitioner, Lordship, others brothers' names are also there in the land, Lordship. So that's why I want to take some instruction. That they are
Because see,
interested.
basically, the ground is that the learned Sessions Court has not even discussed anything. So we'll allow this petition, but in the meantime, if there is something that civil suit is pending, this has been or decided, this may be has become infructuous.
Time, Lordship, because other brothers are there, Lordship, they are whether they are interested or not.
You try to have the instruction over telephone today itself.
Today, I think not possible, Lordship. Next week, any day.
Why not possible today?
Because, Lordship, some other person, Lordship, not the family members, I have got the instruction. That's the problem, Lordship, from Golaghat. Next week, any fixed date, Lordship, I will definitely take instruction, Lordship.
MS. Then so learned counsel for the petitioner submits that the petitioner has in the meantime expired. When?
11/7/2024. That's instruction I have received.
We'll close it. The with a liberty to come back again by the legalers. In view of the aforesaid, expired on
11/7/2024.
11/7/2022. 2024. 11/7. So that's why we are giving you time. 7/2024. However, no application has yet been filed. So in view of the aforesaid, the learned counsel submits that CME will be granted a week's time to complete her instruction whether the legal heirs are interested in pursuing the present application. Prayer is allowed. List this matter on. Not 18th. Don't fix any case on 18th. 14th in the order column. Mm. Mm. None appears for the petitioner on call. By the present application, some value added tax. By the present application under section 482 of the Code of Criminal Procedure, the petitioner seeks to challenge an order dated 27/4/2011 passed by the learned Chief Judicial Magistrate Kamrup Guwahati in CR case number 1140 C/2011, by which cognizance of offense under section order dated 13/9/2000. Order dated 13/9, not cognizance. Order dated 13/9/2012, whereby prayer of the petitioner for representation in the proceeding by their advocate was rejected. 13/9/2012, huh? 27/4/2011, no? There is no order of 27/4. Order dated 27/4/2011. Full stop. এটা আছে না আগোটা? It is on record that a complaint was filed by the Superintendent of Taxes, Unit B, Guwahati, for institution of prosecution under section 85 within bracket 1 within bracket F small f bracketed small g bracketed h bracketed n and bracketed s of the Assam Value Added Tax 2003, read with section 9 within bracket 2 capital A under CST Act 1956 and Section 9 of the AET Act 2008 against partners of Messrs. Ganesh Meat Coke Industries, Ajara, Kamrup. The present petitioners are partners of said Ganesh Meat Coke Industries, Ajara. Pursuant to filing of such complaint, the complaint CR case number CR case number 1104/2011 was registered under section 85(1) within bracket F of the Assam Value Added Tax 2023. Inasmuch as sanction under section 87 within bracket 1 of the Assam Value Added Tax 2003 was accorded for prosecution of the petitioner's hearing by the Commissioner of Taxes Assam under section by an order dated 5th of April 2011. The order sheet annexed along with the petition reflects that by an order dated 27/4/2011 on receipt of the record of the CRK, the learned Chief Judicial Magistrate issued summon to the accused fixing 18/7/2011. The matter was on 13/9/2012. Subsequently, on 13/9/2012, a petition was filed by the learned counsel on behalf of the accused petitioner seeking another date, and accordingly prayer was allowed. Subsequently, on 13/12/2012, accused was absent, and again time was sought by a petition number 4002 for appearance, which was allowed as a last sons and the matter was fixed for appearance of the accused person on 7/3/2013. Thereafter, the matter was again thereafter on 7/3/2013, accused was again absent with a prayer for adjournment, which was also allowed, fixing the matter on 6/4/2013. 2013, and thereafter the present application was filed. Last is 7/3/2013. Okay. 7/2013. This court, under its order dated this court, under its order dated 29/4/2013, stayed the further proceeding of CR case number 1140 of 2011, inasmuch as it is the case of the petitioner that full stop. There is undisputed material on record inasmuch as it is the case of the petitioner that there was a demand of tax amounting to rupees 1 crore. No. It is on record that a notice was issued to the petitioner firm. Demand notice was issued to the petitioner on 6/10/2010 by the certificate officer within bracket taxation Kamrup Guwahati. And by the said impugn notice, by the said notice, the petitioner was directed to pay an amount of rupees 1 crore per month toward realization of recovery of default amount against certain Bakizai cases totaling 4 crore 52 lakh 67 839.00, out of which the petitioner already paid rupees 1 crore 2731 600.00. The balance amount was demanded on monthly installment. Being aggrieved, the petitioner filed WPC, petitioner firm namely Ganesh Medcoke Industries, preferred WPC 2282/2011, and this court, without interfering with such notice, has provided under its order dated 29/4/2011 that the balance amount should be paid with a monthly installment of at least rupees 20 lakhs within 15 days of every calendar month. However, it was made clear in the aforesaid order that in case there is default in payment of the installments as directed, the respondent's department will be at liberty to take action against the petitioner firm as per existing rules and procedure. And it was further provided that the demand notice dated 6/10/2010 shall remain suspended subject to the payment of monthly installment as fixed by the court. Subsequently, in another proceeding, that is WPC 2627/2012, the petitioner was directed by a division bench in its order dated 4/6/2012. The petitioner was directed to furnish indemnity bond having immovable property to the extent of demand, with an undertaking that such property would be kept unencumbered, and the event demand is being upheld, the same would be made by the indemnifier. And it was further made clear that such interim order passed will be applicable in respect of demand beyond 50%, and if more than 50% of demand has already been met. However, it was further made clear by the division bench that The order will not debar the petitioners from reaching an understanding with the consent of the concerned authorities to make balance payment in the installment. As per the pleading of this petition, the petitioner is continuously paying the disputed demands as per order dated 29/4/2011 passed by this court. And in the aforesaid backdrop, the proceeding before the chief judicial magistrate was challenged. Also, none appears for the petitioner or the taxation department to address the legal issues as well as factual backgrounds. However, and this matter is pending since the year 2011. In the aforesaid backdrop, this court has decided to enter upon merit of this court as the fundamental challenge is the proceeding initiated by the learned magistrate. From the record of the proceeding, it is seen that having satisfaction on the having registered the CR case as recorded herein above, a summon has only been issued to the petitioner, and the petitioner had also entered a appearance through the learned counsel before the learned trial court below. Though it is contended in this petition that the prayer for representation of the petitioner is disallowed, however, the order sheet annexed along with this petition do not disclose anything to that effect. Rather, the order sheet reflects that the petitioner's application for adjournment and for his absence was duly considered by the learned trial court below. Full stop. In the absence of any material, this court has also perused the complaint filed by the authorities as recorded herein above, and recording of the aforesaid and reading of the aforesaid materials, if taken on its face value, discloses the offenses as registered, as alleged, inasmuch as this court, in exercise of its power under section 482 of CRPC, cannot go into the factual disputes and allegations as raised in the present case, more particularly when such facts are not admitted by the taxation department. In view of the aforesaid, this court finds no merit in this revision petition. Accordingly, the same stands dismissed. Interim order passed earlier stands vacated. Same order, huh? Common order. These are taken up together. Yes, next.
Made
Yes.
Your Lordship.
Yes.
If this is an application under section 482 CRPC, allegation under section 376, FIR was lodged on 49, FIR was lodged on 29, and thereafter marriage has been performed on 49/2012, blessed with children, living a happy married life, Your Lordship. And therefore, the
Petition is filed by whom?
petition are filed by the husband, wife, and the informant jointly.
Allowed.
I'm deeply obliged, Lordship.
My lord. And at the time, her age was 14 to 16 years.
We'll give the reasons.
My lord.
Item 9.
We want the prosecution to properly concentrate on the real prosecutions which are necessary, not on this husband's wife. Will you convict her? They are having children. Marriage certificate and all. Voter document. Yes,
Yes, this case,
item number?
item number 9, Lord.
Yes.
So quashing of FIR and the charges was under section 498A. And
Where is the FIR?
FIR is in page number 12,
This is item number?
9.
Okay.
page number 14, Lordship.
Page number?
4.
Who are the petitioners here?
Petition is the husband, Lordship.
Petitioner is husband. And others have not come.
My lord, I have flag mark in the search sheet, my lord.
Ah.
Here only search sheet submitted against only
Against
the
only accused.
husband.
No case is made out for interference.
No, no, others are not sent off.
Heard. Anything you want to argue?
Can it be taken up tomorrow?
No, no. Sorry. Enough is enough. If you want, we want to argue, you argue.
Charge sheet we have not received.
In the record it is available.
Charge sheet not received, not received. Your whole case is on FIR. FIR specific demand by whom, on which date, everything is there. That's why I've asked, because if against the other, no case is made out. So I would have quashed if it is there against them, but not against the husband. Specific on which the demand was made, how she has done. So nothing is required. Hard. Swensu and also Swensu. The present application under the present application under section 482 CRPC is filed for quashing of FIR in Mankasar PS case number 512/2012 under section 498 within bracket A section /34 of the Indian Penal Code. The respondent number 2 has lost the FIR on 15th of December 2012 before the officer in charge Mankasar police station against the present petitioner who is her husband. As per the FIR, the present petitioner married her as per Islamic right, Islamic Shariat law on 13/4/2012, and thereafter, during the conjugal life, the accused, on the ill advice of the rest of the accused persons who are in-laws of the present petitioner, impose pressure upon the in-laws of the petitioner, impose pressure upon the victim to bring cash amount of rupees 2 lakhs as dowry from her parents. According to the FIR, the accused number 1 and his family members started to beat her and inflicted inexpressible torture upon her on being failed to pay the money demanded by her parents. And on 10/11/2012, she was beaten up and she was drove out of her matrimonial home at around 2 a.m. in the morning, and also poured kerosene oil and tried to set fire on her. Consequently, she took shelter in her parental home with the help of her neighbors, and thereafter lodged the FIR. There was some delay in lodging the FIR, which was explained to the effect that as there was a social adjudication, there has been a delay. On the basis of the aforesaid FIR, Mankasar PS case number 5112/2012 under section 498A/34 IPC was registered. The learned counsel learned counsel for the petitioner, while assailing such FIR, argues, yes, what is your argument?
Lordship, he was not there at the place of occurrence.
Huh?
The petitioner was not there at the place of occurrence.
Argues that the petitioner was not at the place of occurrence at the alleged at the time of commission of the alleged offense, inasmuch as he was a student studying engineering in a college elsewhere. Yes, second ground.
Second ground, on that day, the informant was also not there.
It is also a contention that on that day, informant was also not in the place of occurrence. Rather, she was
at her parental house.
she was at her parental house. Therefore, and that is these two grounds. And therefore, it is apparent that this is an abuse of the process of process, and the FIR has been lodged with a mala fide intention to harass the petitioner, isn't it? On the other hand, though none appears for the respondent wife, however, a written objection has been filed in the criminal petition objecting quashment of the FIR, and certain details were elaborated how she was meted with cruelty and demand of dowry. Mr. Swenson, learned additional public prosecutor, on the other hand, submits that this court should not may not like to exercise its power under section 482 CRPC in the given facts of the present case, inasmuch as if the FIR is read in its entirety and is treated to be correct, the same discloses commission of offense under 498A, inasmuch as after completion of the investigation, the investigating authority, investigating officer has already filed a search sheet, being search sheet number has already filed charge sheet,
My lord,
has already search party
I have
Wait,
flag mark.
huh?
I have flag mark in the
Uh,
record.
in the record, na search sheet, search sheet wherein the present petitioner was sent for trial having sufficient material, and the other and however other accused person named in the affair will
Not
not
sent.
stand for trial, not stand for trial. Full stop. I've given anxious considerations to the arguments advanced by the learned counsel for the parties. Full stop. From the reading of the FIR in its entirety, and if it is taken on the face value, it cannot be said that the allegations are omnibus allegation. Rather, a specific statement is made how the alleged offenses were committed. Alleged offenses were committed. The argument of the learned counsel for the petitioner revolve around factual assertions such as plea of LIB, as well as the fact that the victim was not present at the place of occurrence. Full stop. It is by now well settled that while exercising its power under Section 482 CRPC, this court cannot enter into such disputed factual aspect, though this court will not be powerless in a given case to examine the details material available on record to look into whether what is that judgment, to look into whether the application was filed whether FIR was filed with malafide intention or to harass the petitioner. This court has also perused the record of the GR case, and those record not necessary. This court do not find anything to suggest that it was the FIR was filed with a malafide intention. Rather, it is not a case of the petitioner that it has been filed on malafide. Rather, the case of the petitioner that it was filed with malafide intention rests on some factual assertions which cannot be entertained by this petition under Section 482 CRPC. Accordingly, the present criminal petition whatsoever stands dismissed. Interim order stands vacated. Full stop. The LCR be sent back forthwith. Yes, next.
Here is also complaint case, my lord. Here it was stated on 6/5/2020, 13 my lord. 448, 380, and 427 IPs.
Can we dismiss this 482 application for default? What is the law? Criminal appeal we cannot. Yes, Thakur. Revision 482. When quashing and all.
Quashing maybe, my lord, there is no such bar, my lord.
Any law that there is no bar? Why should we dictate and waste time of all these things?
One last chance may be allowed.
No, I will not give any last chance. No scope of any last chance. 2013. We are in 2024.
13.
Enough chance is given. Let it be. None appears for the petitioner on call. I'll be exhausted dictating. Funny. None appears for the petitioner on call. Yes, Mr. Sahayola, please advise us and enlighten us.
My lord,
Can we dismiss this 482 petition for default?
I don't think that it can be disputed.
Because it's not criminal appeal. These are quashing petitions.
Even then, my lord, because subsequently restoration or everything and nothing live under criminalization. So it will be dismissed on merit, my lord.
Will all merit decide it. No need to appoint amicus.
No,
in
not
482.
not necessary.
Only on criminal appeal.
Not necessary, man.
Okay.
Not necessary. It can be decided.
None appears for the petitioners on call. The present application under, just write it down, 482 is filed. 482 CRPC is filed. Assailing an order dated 9/4/2013 passed by the learned SDGM within bracket M, Bishwanath Sariali, Sonitpur in CR case number 49 of 2013. First of the basic grievance of the fundamental ground of challenge is that the learned SDGM issued the summon dated 9/4/2013 in CR case number 49 of 2013 to the petitioners who are not named in the complaint itself and in the evidence in chief. First of all, the complaint case was filed by the respondent number 2, alleging that on 7/4/2013, at around 1:45 p.m., the accused name namely Umashankar Jaiswal, Ajanti Jaiswal, Abhinav Jaiswal, Abhishek Jaiswal, Sanjay Jaiswal, Srimati Aruna Bora, Srimati Sajanti Gupta, the petitioner, Srimati Rita Gupta, Sajanta Gupta, petitioner number 1, Srimati Rita Gupta, Srimati Kusum Sahu, petitioner number 3, Srimati Meera Devi, petitioner number 4, and Srimati Madhuri Kumari Bhagat, petitioner number 5. Total 11, isn't it? 5. And some unknown person entered into the house of the informant and asked her to vacate her tenanted premises. Immediately, and threatened her that otherwise she will otherwise she'll be forcefully thrown out and the possession of the house will be taken over. It is also alleged that when she resisted, the accused person went away from the place and then they entered into the house of the informant, complainant, situated at Bishwanath Sariali, situated at Pavoi Road, Bishwanath Sariali, and forcefully entered into the house and took away different valuable properties, which cost is about 1,61,000, 65,000, and also took away an amount of rupees 1,61,000 and locked the premises. On the basis of such complaint, and complaint, the CR case was registered, and the complainant was examined by the learned. During her statement recorded under section 200. 200, huh?
I have flag mark, madam.
200 CRPC.
Other witnesses are also.
She has reiterated her stand as taken in the complaint petition and named one Uma Shankar, his wife, Ajanti Jaiswal, Avinash Jaiswal, Abhishek Jaiswal, and Sanjay Jaiswal, and other 15 to 20 members from the Mohila Samiti, local Mohila Samiti. The complainant also examined one Mrityunjay Bardhan and with Mrityunjay Bardhan. And he examined, and during his examination, he deposed that some ladies, some female person came to her house and asked them to vacate their rented premises, and thereafter the aforesaid ladies entered into the room and forcefully entered and vacated the premises. He specifically named Umashankar Jaiswal, Ajanti Jaiswal, Abhishek Abhilash, and Sanjay Jaiswal, one Aruna Bora, Kusum Sahu, and one person with Gupta title, and also ascertained that an amount of rupees 1,60,000 was taken away. Thereafter, the magistrate, where is the summon? Where is the order of cognizance? After it, by an order dated 9/4/2013, the magistrate has taken cognizance under section 448/387, 427 of the IPC. Now, how do you deal with these persons are not named in the whose names are not there?
But FIR in FIR, all of them are there.
There.
But
FIR
witnesses, two witnesses examined and CW1 and CW2.
Two.
My
CW1 and CW2 named many others,
Many
but
others.
not these.
my lord,
They said some other.
my lord.
Some others are there.
Includes them also
But
there.
can that, because there is a offense under 380.
380 also there, my lord. And all the lady entered the house, my lord. And complaint will be very known about all the accused person, my lord. Petitioners. Only someone issued they may appear, my lord. That
No, why should we face that trial unnecessarily?
Why?
This is one
my
aspect.
lord.
Second aspect is their names are not there. None of them has been except some Gupta.
My lord. Title Gupta.
Sahu and Meera Devi all are not named. They are also not said that these are the in the complaint or them these are the secretaries or presidents. 34 is not there.
34 is not there. 380 allegation is
380.
380. 448 will come. Then 380 my lord.
458 will come.
My lord.
What was the 448?
House trespass.
House trespass. What do you suggest? Please assist us. See, two way of taking it.
My lord.
Thus, evidence, the statement under 200 may not be the first because there will be other evidence. But at the same time, there must be satisfaction,
Right.
there will be synchronization between the complaint as well as under 200.
Witnesses.
And in 200, complaint she has named all these
All
persons,
these,
but
right.
200, no implication.
Right.
How do you proceed then if no implication under 200? Okay, of course, it is said that some ladies.
Right.
So once she say I am identified, and some ladies they have not named her role,
Well,
and she could maintain others' role.
complainant identified all the petitioners. In the FIR,
Where is
in
in
the
her evidence?
FIR,
Huh?
FIR,
No, no,
FIR
FIR
name.
identified,
Right,
not complaint day she has identified.
complaint.
But
No
see,
complaint.
in deposition, because why this initial deposition? Magistrate will
Hmm.
have to have a satisfaction that
Yes.
yes, what have been stated in the CR case is.
Right.
Now, looking into two ways. One is that, okay, this, it has been stated that these are specifically identified,
Right.
others, some others.
Others, right.
So therefore, some others may include, that will be a matter of trial.
Trial.
But other view is that when you can name everything in a complaint petition, it is not a
But not in
investigation,
the-
but not
in
this,
the-
why should they suffer? So from the aforesaid, it is seen that though the present petitioners are named, specifically named in the complaint petition, no specific role has been attributed either in the FIR
Complaint.
and either in the complaint
Sure.
or in the statement recorded
Under-
under section 200 CRPC. There is also no other material to suggest either in the FIR, either in the complaint or in the deposition under section 200 CRPC to even remotely suggest that the present petitioners are the members of the Mahila Samiti or the member of the Mahila, the ladies group, though their name specifically found place in the list of accused persons. But body of the complaint do not disclose
Their role.
do not disclose their role, though specific roles are disclosed in respect of some of the accused persons who are not before this court. The name of one Umashankar Jaiswal, Ajanti Jaiswal, Abhinash Jaiswal, or Abhishek Jaiswal, and Oruna Bora and Soijar Jaiswal's name specifically appears. Therefore, in the considered opinion of this court, on the basis of the complaint as well as on the materials available on record, including the statement of the witnesses recorded under section 200 CRPC, do not disclose any offense under section 448, section 370, 380
and 427.
or section 427 IPC, even if the aforesaid complaint as well as the statement recorded under section 200 are taken in its face value as and are taken to be correct. Therefore, the petitioners have been able to make out a case for interference under section 482 CRPC. Accordingly, the present application stands allowed by setting aside and quashing the criminal CR case number so and so and order dated 9/4/2013 passed in the CR case number so and so. So far, the same relates to arraying the present petitioners
Only.
as accused. Full stop. Any LCR? No LCR. Okay. none appears for the petitioner on call. None appears for the parties on call. Is the counsel for in this petition? Item number? Will refer the matter to the bar council. The misconduct. Whosoever.
My lord. One name is of Mr. I'll just, 1 minute, I will just get the instruction from him.
Is a misconduct.
Yes.
See, we cannot dismiss a petition
Yes, yes.
for default.
Yes.
Now, in certain cases, some factual things are necessary to be ascertained at this distant day, appeal of 2000, revision of 2012.
Yes.
Can a amicus do this? Who is S. Goswami? We will pass this order after some time. We'll call the next case.
Morning time, you have make a mention, because of that, the learned counsel B. Chaudhary is out of station. I am not in this case, my lord.
What remains in this case?
My lord. Maintenance case,
Maintenance.
yes. The pleading is complete, my lord, respondent also appeared.
Nobody is appearing.
Yes, my lord. Their name in the, shown in the cause list also. A.K. Bhattacharya, R. Sharma, Pisha.
We'll dictate this order, these two orders at 2.
My lord, this order, my lord, fixed on tomorrow, my lord.
No.
He will come tomorrow, my lord, learned counsel B. Chaudhary, my lord.
What remains? 1,500 rupees is
Yes,
awarded.
yes,
Where
yes.
should you, what order will pass today will pass the same order tomorrow.
Tomorrow-
482 petition.
Tomorrow, my
The
lord,
question, his whole argument is that marriage is been declared by a court when there was marriage is doubted.
That's
We'll
true.
clarify that.
that's true, my lord.
We'll
But,
clarify that.
order-
That is to be decided by civil court in appropriate
Yes,
forum.
yes.
But so far the purpose of this is a prima facie view. That is what we will clarify.
That's true, my lord. But the order was passed in presence of this council, my lord.
Those days are gone. 2003, we have already have issued notification yesterday that from owners no adjournment. It's frustrating.
Yes, that. Nothing to say, my lord. I am not
It's
in this council.
frustrating. Nobody is
Just he
appearing,
of-
no assistance. Why should we adjourn?
I am appeal, my lord. Just he over telephone, my lord, inform me, my lord, kindly.
Okay, this
pass my
matter
call
tomorrow.
Tomorrow, my lord. Just-
Tomorrow. Yes, next call next.
just-
Matter next matter cases. Yes.
Also here, we have challenged the complaint, my lord,
Hmm.
under 482, my lord.
Hmm.
Here, a complaint has been filed alleging that 4 checks
Hmm.
bearing 50,000 each have been dishonored by the bank, my
Hmm.
lord. Dishonored by the bank at Lamding, my lord.
Hmm.
The complainant has submitted the checks to his banker, my lord, at Guwahati.
Hmm.
And those checks has been dishonored at Lamding, my lord.
Hmm.
Now, the main, my lord, the basis of filing of this case is that the complainant herself is also the account holder of the account from which the check were issued.
Hmm.
The check, the complainant is one of the business partner, my lord. 4 partners are there, and complainant is one of the partner, my lord. And this or that, I don't know, my lord, the complainant refunded, wanted to get the money. Then their partners have issued 4 checks, my lord, from the said account, my lord.
I understand.
Yes,
One is an accountant, accounts of the partnership firm.
yes,
Check was issued from the
from the partnership
partnership firm
account, my lord.
in favor of one of the partner,
One of the partner,
who is also account holder.
account holder.
Is it not permissible? Suppose from the partnership firm, some due is dear to one partner, say out of profit, something like that.
Not, it's not that, my lord.
No,
but-
it's not that we cannot, a certain factual matter.
Yes, my lord,
So
yes,
is
my lord.
there any bar issuing, the partnership is a legal entity.
Yes, my lord.
Somebody is an authorized
Yes, yes,
signatory.
yes, my lord.
Now the authorized signatory issues a check to an individual who might
Yes.
be the partner.
Yes, yes,
Check is issued, check is dishonored.
yes. So, my lord,
Is it not permissible?
No, because my lord,
We'll have to can that be ascertained in 482 whether there is legal due or no, individual due?
no,
or
I am not going to that.
Okay,
Whether,
then don't argue that.
yeah,
Next.
then law permits or not, my lord. The whether from that she herself is a check account holder, my lord.
She is not herself account holder. The
Yeah.
partnership is the account holder.
My lord.
Partnership firm.
No, partnership firm. And then the account number is a joint account holder, joint account.
With partnership firm.
Yes,
and
yes, having a joint account, my lord.
C. Account from which check was issued. It was in whose name?
Partner,
Name of the business house.
Yes,
Tell
yes,
us.
my lord. The account, my lord, your lordship may kindly look into another, my lord. Then you'll do.
Please tell us.
Yes, my lord. Yeah, certificate is there, my lord. Yes. Page 29, annexure 5.
Name of the account holder. Name of the account.
Yeah, here, the bank has certified it.
Okay.
Annexure 5, page 1. This is to certify that Mr. Tapos Bag, Sarup Datta, Mr. Pallav Dhar, and Mrs. Lily Das of Messrs Constructive Commercial having their registered office at Joy Complex, Krishna so and so Lamdin, have their current account number so and so, have their current account number. So, she's also one of the.
So it's a joint account. Why? Please tell us. It's a joint account.
Yes, joint account.
Of our four
Yes,
of
my
us.
lord. Yes, my lord.
Suppose we are doing some business, something like that.
Yes.
So it's a joint account for the purpose of business. Now something is due to him. So we issued a check to him.
But just my prayer is that whether, my lord,
It's permissible. It
whether
will not be permissible if facts
no,
is
because
something.
because it is not negotiated, my lord. The instrument what she has, it cannot be negotiated because she herself is the account holder.
No, she is not herself. Two accounts are different. One is an individual, one is a partner.
Yes, of course, my lord.
So if it is an individual entity,
And okay, this is one aspect of the matter,
and
my lord,
other-
I have filed.
other
And other is the jurisdiction, my lord.
jurisdiction, the recent, what is the judgment says, where is to be filed?
That I have not prepared. The recent judgment I did not come, my lord.
No, you did not come. We'll enlighten you. We
Well,
wanted to be enlightened from
because
lawyers. Now we'll enlighten the
that
lawyers.
cause of action arose at Lamding.
What is the judgment says? Recent judgment. Where is to be filed? There are some clarifications in the judgments. Where is to be filed? Where there will be jurisdiction.
Because of the 180.
So that has been interpreted by Supreme Court. There is many disputes. What should be the place of filing a complaint? Where not?
That, my lord, tomorrow or day after tomorrow.
No, today at 2.
At 2, I have another case, my
You
lord.
do another case. We'll handle with this. You do other case. I will be the lawyer for the petitioner as well as for the other side. You do your cases. Not necessary to argue 2013 matters. All.
You, Boris.
Where is he?
Lordship.
Yes. What do you say?
My lord, why I am seeking review, my lord?
No, review, we understand. Where is the other side?
Mr. Boris here. Yes, Lord.
I have not seen him. Yes, you are for the respondent.
Your Lordship, yes.
What do you say?
Lordship, I haven't reached, but I have no objection. If there is a
But Mr. Ratan,
yes, my lord.
I do not think because we have clarified that this will not be implemented till date. Everything will depend upon the civil court decision.
My lord, in fact, the bar decision itself is null and void because it is being passed ex parte.
No, that is null and void or not is having no relevance when the matter is being taken up by the civil court. If civil court decides in your favor,
yes,
okay, then nothing will happen because that is
lord,
nothing in the eye of law. We have made an observation that will be subject to the outcome of the civil suit.
My lord, in the event my civil suit fails also,
If you,
then
even if your civil suit fails, then
that,
what will happen?
they don't have not made any counterclaim, my lord. My lord, these are, in fact, the impugn or Keba decision itself is
No,
null and
no.
void.
Suppose your suit fails,
Yes,
then
my
that
lord.
remains.
My lord, in that event also, they are not the owners.
No, that is to be, everything will be decided in the suit. Okay,
My
heard
lord.
Mr. Ratan, learned counsel for the learned petitioner in persons. This review, I'll apply my mind. Let me think over it. This
My
is
lord,
a review application against order dated 25/10/2024, passed in CRP number 17 of 2023. Issue notice returnable on given date. We'll decide on that day. We'll come prepared. Everybody
Yes,
will
my
come
lord.
prepared, decide.
Yes, my lord, that will amounting to like, because
We'll hear you. We'll hear you on 4th of December 2024. On that date, as Mr. Your name please, Bori, as Mr. U Bori has entered appearance for the respondents, no formal notice need be issued. Full stop. Place this matter on 4th of December 2024 for final disposal. Okay, we'll do it. No? What is the list, cause list? Yes, where is Madam Nikita?
Oh, my lord, I am appearing on behalf
Anybody on behalf of the respondents?
Yes, I am, my lord.
Huh?
Odugong. Respondent Odugong, my lord.
You are appearing for all the respondents?
Yes, my lord.
Your name, please?
Odugong, my lord.
Oh,
My
Dugong.
lord, yes, my lord. I have received the copy today, my lord.
Okay, then.
I
When
have
will you
to,
fix it?
my lord, on any date in the month of December. 10 of December. if
10th of
possible.
December. Okay. Review petition. Decision application. As Mr. Oken Dangang appears on behalf of the respondents. Okay. Tin number. Oken Dangang, cause this concealable. Appears on behalf of the respondents. No formal notice need be issued. List this matter on 10th of December for final disposal.
My lord, on 10 December, I have that is preoccupied. Can it be listed on 12th December?
12th of December. Okay? 12th of December.
12, I have a case, my lord. 11, my lord. Oh, okay, 11.
11th?
Yes,
In
my lord.
between?
Yes, my
Okay. 11th of December.
lord. Much obliged.
We'll decide on that day everything.
Obliged.
Yes, it is. 10:32 নটা আগতে প্ৰথমতে ক্ৰছিং লেফ্ট over নটা then go to the admission. Why this matter is listed before this court?
Because of the order of coordinate bench.
Where is that?
Order dated last order.
Where is that? It's difficult. I'll have to have a consultation. See, in this case, specifically in your case, bail has been rejected by a coordinate bench. That will get preference, or I have granted to some co-accused will get preference.
No, after that we file SLP and therefore while SLP we withdraw the SLP and it is said if the trial do not proceed further, then you can renew your prayer for bail.
Where is that?
That your lordship will find page 86.
Page
86.
This was in 25/4/2024. An earlier order was rejected when?
On 23 to 24.
23/2. Against that, you have gone there. 24. And what happened thereafter? Please tell us that.
Third one synopsis with list of dates. Lordship will find that.
All the facts are there,
Yes, all the.
including the rejection, Supreme Court and all.
Everything is there, Lordship. Lordship may kindly see that synopsis once.
What happened after 24? Tell us that.
That in second page, your lordship will find that dates are there. No witnesses are examined till date. The position is same.
16, column number, point number 16.
What happened on these dates? Who
No
took
witnesses
time?
were examined.
Huh?
No witnesses were examined. Even PW.
No witnesses appeared.
Only PW4 who was whose examination was partly taken.
When on 9th of October 2024.
And his further examination was reserved because MR was not there. That envelope with which the contraband was seized. Subsequently,
How do you get these orders after from 9th of October 2023 till 30/10/2024? Can we get these orders?
I have the certified copies.
Huh?
Certified copies.
You are having?
Lord.
Just give us. Yes, Bhattakur, what you say?
Yes, well, otherwise for Supreme Court order was passed on 23. Thereafter, my lord, yes, from the case record I have gone through, my lord. It seems that, my lord, many dates were fixed. Last date fixed on, my lord, 19/9/24.
30/10.
On that day, my lord, PW.
Last was 30/10.
That order is also there.
30/10.
Second.
On 19/9/1, SI Raspat thing was examined. Raja Pratap Singh.
PW4 appeared various times, but because they have a lot, they could not produce that MR. Because of that, further examination in chief is still could not be completed.
See, orders are there.
Yes.
Okay. Third order reserved. We'll see. Well, I'll go details. What. Why earlier rejected? Everything is there. Okay.
Only thing is that there are various contradictions regarding how the contrabands were seized.
That will see.
That your lordship may kindly see.
The witnesses will see, because I will not go only by this. I will also go through the materials. What are the materials against you?
Yes.
Allow me to point out, lordship. Your lordship may kindly see that witness, the seizure witnesses says that the investigative, the IO called them over telephone and asked them to appear at the spot. But police officer says they took the witnesses along with them.
There may be, because they called it, they met in some other place and they went together.
No, the witnesses said, lordship, on the place of occurrence, they saw 25 persons along with the police already there. How they came, because this is relevant, because your lordship has already observed the third accused was granted bail. He was brought subsequently to the place of occurrence.
But
But
brought subsequently.
that he was there. So that is why I'm pointing out the.
But regarding that accused, my lord, he was subsequently brought.
He was subsequently brought.
Yes,
That was
but
clear.
regarding the present two accused, your lord,
They were
kindly-
clear.
there was earlier rejection order also. In that order also, my lord, regarding the my lord, findings of this honorable court regarding PW1, PW3, and
That is there.
one independent witness, everything is there, my lord.
Okay.
Otherwise, there are materials against the present two accused persons. my lord.
Okay. How long? For delivery, reserve, order reserve. Order reserve, that's all. Okay, one. Yes, what is this?
Lordship, this 439
Why
application,
this is listed before this court?
because Lordship, all the co-accused got bail from this noble court.
Uh-huh.
All the persons got bail from this noble court, Lordship, as per the Supreme Court judgment, Lordship, one affair, one court, Lordship.
One affair.
One affair, Lordship. That is when latest judgment, Lordship, 24 judgment. That is why this is before your Lordship. So, Lordship, in this case, six numbers of persons arrested, Lordship. 4 were inside the vehicle, and thereafter 2 persons arrested from.
Where is the affair?
Affair is page 10, Lordship.
Which case? Where is the earlier orders passed in earlier cases?
Early cases, only one order I have annexed, Lordship, but other, it is by Ajit Bordhakur, but it is in the side of the this file, Lordship, court file, Lordship. Your Lordship order, case number is mentioned, Lordship. The person is inside the jail for about 3 years, 2 months, 7 days, Lordship. 9 numbers of witnesses cited as witness. Out of 9, 3 examined only, Lordship. And since 2 years, no witnesses adduced by the brought by the prosecution, Lordship. Till today, charge frame on Lordship 9/3/2022. The Lordship order is there, Lordship. Defendant. Correct. Oh, defendant.
It was granted on the ground that the third accused was arrested on the basis of a confessional statement which is not admissible.
Simple.
Huh? It is what?
It is also one of the judgment.
That we are reading, that I have already collected, yes. So in that case, in that accused, the ground of releasing him on bail was that he was not placed in the place of occurrence. He was apprehended on the confessional statement of the other co-accused from whose recovery was made, that is from the Bolero. And therefore, relying on Palulbid Ahmed, that confessional recorded under section 67 of the NIVA will remain inadmissible in trial as well as in the bail. Stage of bail, therefore we granted bail. Now, what is your argument?
Sir, I'm not only on that, Lordship. The persons were intercepted on 28/2021. Thereafter, Lordship, after investigation, charge sheet was submitted. Then charge frame on 9/3/2022. And 9 number of witnesses listed in the witness list. And out of 9, Lordship, only 3 examined.
Now, who are these 3 witnesses?
3 witnesses, independent witnesses also there, Lordship. They have not.
Now, let us see what independent witnesses said.
Caesar witnesses.
Caesar witnesses.
My lord, that is flag mark there.
And Lordship, they are inside the jail. All the other person got bail except this person.
Two numbers.
How do we say? Only
But
this
yeah,
person.
here-
Where is the orders? Granted by whom? All granted by this court.
Lordship, it is mentioned in the case record, but in the side, Lordship.
Where in the side?
Right? This one.
দুটা হে বাকি 4জন কাস্টডিত আছে
Very late already. And Lordship, I am on long incarceration, Lordship. 3 years, 2 months, 7 days, Lordship. I was
What
voted
is
in.
the order by order in 3274? I want all these orders to be looked into.
Then Lordship, I'll place this all the orders.
That is important.
Lordship. I'll place this on.
You people are showing very urgency, but you are not well prepared.
I'm sorry, Lordship.
What questions will be asked? You are not well prepared. but you show so much of urgency. But you are not, nobody comes prepared.
Can it be on Friday, Lordship?
See, one point you must be clear. I have already delivered a judgment where I have said, yes, law inculcation can be a ground. But can we bypass everything? If there is direct evidence is there, materials are there, we are totally satisfied.
I'm not on that, Lordship. Lordship, kindly, I have one query, Lordship, regards to the prosecution. I'm okay with this. How long they will be inside, Lordship? They are not bringing the witnesses.
No, don't ask question, answer.
That is
It
correct.
is not a
Lordship.
place to ask question.
Lordship.
It is a place to answer
No, no, this is-
questions. Now,
this
where
is
are
my
those
question.
other orders?
Well placed, Lordship.
So that we'll have to see what are the considerations, why it was not granted, why one matter is here, other matter is disposed of by another, one is why this was not placed properly before the court. We want to know, please show us these orders.
On Friday, Lordship.
Not Friday, it is on 12th.
Probably.
My lord, I'm sorry, my lord, in this case, now I cannot stand in that stand. My lord, fact is that it was a referred case from the Chamber of Advocate Bimal Setri. At that point of time, it was filed by me and Advocate P. Sharma was appeared. He is no more now. P. Sharma.
Now see, only
Yes.
one, who is for the respondent?
My lord, I have now talked with B. Setri. He's not, today he is absent, my lord. He will appear, perhaps it is, my lord, infrastructure. I don't know, but
No, see, that's why we know that factual, if
Yes.
I can appoint an amicus, no problem on
Yes,
it.
yes,
I and decide on merit. In this case, there are materials to suggest that, see, if we go by merit, we cannot interfere with the interlocutory order. As simple as that. I can dictate this order, 5 minutes, I will dismiss your petition. But we are not, you are here to do justice.
my lord.
Admittedly, these two husband and wife got divorced with a permanent alimony. Now, this was an interlocutory order. Now, what happened to that proceeding? Nobody knows.
My lord.
I can ignore everything and pass this order on merit.
My lord,
It will take 2 minutes to dictate this order.
I have talked, my lord.
Why we are taking so much of pain?
My lord, he
Even the wife is not here because they are happy. They are settled. And we cannot pass on that ground that since they are not, have not appeared, they have compromised. You cannot presume it.
my connection.
Who is
B. Setri will appear, my lord.
tomorrow?
My lord, I'll, yes. Sir.
Otherwise, tomorrow we'll decide, then whatever music you will play, Then everything will come upon this officer. Even after compromise, we'll go by the merit. Leave
Malak-
this matter tomorrow.
Tomorrow. My presence may not be.
No, I'll not
No,
record the presence. Yes, what is the provision? Where is to be filed?
Only one day, man. Because my
If
It
I
is-
grant every day, one day time.
my case is before amendment, man. So that's old NI Act I have to go through, man. Only one day time. So whether the after amendment, this thing.
Now,
escape
this is
or
a,
not,
this is a,
then I have to search my lord.
dear, this is a procedure, no substantive, it is not substantive right. Procedural, when it is procedure, suppose BNSS has come, what will be applicable to the present trial?
Yes, of course, my lord.
Huh?
Only one day time. Only one day.
Tomorrow.
Obliged.
What do you say? Good. Yes,
Very short question involved in this case.
Yes.
The prosecution sanction under section 197 was necessary. Now the facts, my lord, this goes this way, my lord. Then-
prosecution sanction was necessary. It was not there.
Not-
It was dismissed. So therefore, on that count, it was, the complaint was dismissed, isn't it?
No, no. My lord, here what happened, initially, my lord,
This is an offense under,
my lord, 218,
this is item
217.
number? Okay.
217, 218 and 219. But initially, my lord, FIR was lodged by the my lord, police against my lord,
This is reinvestigation or what?
lodge. Firstly, the investigating officer submitted a final report.
Hmm.
The magistrate did not accept and directed for a reinvestigation by a different officer. Then the
Is this special judge is having power for directing reinvestigation? Possible. Okay.
Or is there. So accordingly, reinvestigation was ordered. Then I was interested. I was at that
Reinvestigation or further investigation? Can there be reinvestigation? Direction? That is the only, that can be the only ground for interfering with. I think power of reinvestigation is vested with the constitutional court like this court and Supreme Court.
Yes, yes.
It can be further investigation. So here it is a reinvestigation by a different agency, different officer or something like that, isn't it?
IO, my lord. By a
Can
different,
that be done by, what is the power to reinvestigate? Which provision of CRPC?
no, my lord. Here, my lord, the magistrate having found that the investigation conducted by me was not according as expected by the court.
No, that we understand. Therefore, the vital question is, suppose a final report is submitted, court can, on the basis of material available on record, may give a further investigation. But is there any power to direct reinvestigation? Because I am not happy investigation was not done. This is the issue, I think. What is the law?
That issue, my lord.
Yes. What is the issue then?
My lord, issue is, my lord, so far as the further investigation of the case, my lord, is the main case. Now, while the magistrate, my lord, not accepting the final report submitted by me, not only, my lord, directed for
Okay, this is
further
not
investigation.
this is by the officer himself.
This is by the officer
Okay,
himself,
not by the.
not by the accused.
What happened to that?
And my lord, what I have been informed, my lord, that subsequent officer who was again entrusted to further investigate, he has, my lord, out of seeing all these things, he has submitted a charge sheet.
Okay.
And the trial has proceeded and the person has been acquitted.
Okay.
The original complaint.
Okay.
But then particulars are not there because I had, my colleague had also talked to the present petitioner. He's almost in the
Now let us see 217, 218, 219 IPC.
This is my dereliction of duty, perfunctory discharge of duty, etc. my lord.
The order of the learned special judge is there in the first page of the record, Miller.
That is page 27, it ends at page 27, isn't it? Operative portion is page 27 of your petition.
Order
Starts at
learned
page
special
22.
judge.
Lordship. Starts at 22, operative part, my lord, will find
17.
26 onwards, in view of the last paragraph, in view of my discussion in the foregoing paragraph, final report number so and so SAP police is rejected. The superintendent of police vigilance anti-corruption department is directed to reinvestigate the case after taking into account all aspects of this disappropriate case and to complete the reinvestigation within 3 months.
So again, reinvestigation. What is his power of reinvestigation? Anyway, that is not the issue here.
Let a copy of this be sent to the learned Chief Judicial Magistrate Kamrup Guwahati to register a complaint case under section 217, 218, 219 IPC against accused Deputy Superintendent of Police Sri Pradeep Chetia, now posted at Dibrugarh, the Supervisor so and so. Accordingly, this order was forwarded by the register and a complaint case was registered and process was issued. So I'm challenging that order of issuance of process as well as this order.
Now, how 207, 218 and
from the body of the order, it appears certain document.
no, that we understand. How this complaint is to be filed under 217, 218, 219? Is it an any special provision for this?
It will be section 190.
Section?
190.
195.
190. Filing of a complaint. So far as the giving false evidence, etc., that is governed by
195.
Lordship, my lord.
Isn't it?
Lordship.
That is 195.
That is 195.
Now this section 217 and 219 will not come under that chapter.
Not.
This is not under this chapter.
Not.
That is CRPC.
340 deals with the making false statements, etc. before the court. In that case, the magistrate, the court can direct to lodge a complaint before the magistrate directly, and it's
What was that
different.
chapter? So do you say that there is no special prescription under CRPC for the separate complaint for this section? No. No, that since like other sections, public servants,
340
judges,
340
340.
340, when a person gives a false evidence before the court, etc., that is one procedure. Otherwise, my lord, it is either
Under normal complaint.
normal complaint. Only difference would be that complainant being a public servant need not be examined under section 200.
And section, according to you, that is 340 is relatable to 195. Offense, is
So
not it?
that will be giving false evidence, etc. etc. 340.
That is mentioned in section 195.
Yes.
For 195, those offenses are there. 340 will be applicable. But so far relating to 195, these sections is not covered under 195.
Specific sections are given in 95.
170 to 188.
Right.
Then 205 to 211 and 228. So therefore 217, 18, 19 will not come under this. That is what I wanted to have a clue. Okay, now what is your ground? One is sanction and other?
Sanction, and secondly,
No case is made out from the materials.
my procedure of making the investigation may be faulty or etc. For that, departmental proceeding may be initiated. Authority may go for that, but the court, my lord, attracting this provision, 219, my lord, 217, 218, not at all, my lord, attractive. My lord. Extra copy of execution.
Which are the important paragraphs?
In the impugn order.
Yes. Heard Mr. Saikia, learned senior counsel, assisted by Mr. K. Saikia. Also heard Mr. Bhattacharya. Nothing is there.
Yes.
Mr. Bhattacharya, learned counsel for the learned additional public prosecutor. The present application under section 482, 482 CRPC is filed assailing an order dated 21/1/2013 passed by the learned special judge Assam, whereby the learned chief judicial magistrate Kamrup Guwahati was directed to register a complaint case against the petitioner under section 217, 218/219 of IPC. Full stop. The brief facts leading to the final present petition can be summarized as under.
Well, I would just like to point out here, order is not for further investigation. Your lordship may kindly peruse in both the time reinvestigation.
Reinvestigation. Reinvestigation cannot be.
Yes.
We are not going to that because reinvestigation, if we already that is gone, we'll
Yes,
we'll
I am
go.
just
we'll-
pointing out.
that is why I'm because I have just we will not just I had gone through the order, so it was in my mind that how can there be reinvestigation? That's why I have asked you. But reinvestigation part has already been implemented.
Yes.
That charge sheet has been filed. So at this stage, we are not going on to the. That one Ghanesham Sakya, Deputy Superintendent of Police, Vigilance and Anti-Corruption, Assam, lodged an FIR before the officer in charge comes Superintendent of Police, SCB, Anti-Crime Branch, is that it?
Gotcha.
Anti-Crime Branch, Police Station, Vigilance and Anti-Corruption Branch, Police Station, Assam,
Yes.
SCB, PS. Inter alia alleging that during inquiry of RE number 55 within brackets 7 of 2002, it was found that the present petitioner, namely Azizur Rahman, okay, that one Azizur Rahman Majumdar, then APOT DRDA, Kachar has acquired both immovable and movable properties during tenure of his service with effect from October 96 to April 2001 by adopting corrupt practices by abusing his power and position as public servant. It was further recorded in the affair that during inquiry, it was found that the said officer had earned an income of rupees 15,39,695 from all of his known sources, whereas he had spent 1989,689 in maintaining his family and acquiring properties, including saving and investment during the period. Accordingly, SCB PS case number 13/2004 under section 13 within bracket 1 within bracket E/13 within bracket 2 of the Prevention of Corruption Act 1988 was registered. Full stop. Thereafter,
Actually, also will get in page 23.
Thereafter, after completion of investigation, what is your name?
I am Pradeep Chetia.
Huh?
Pradeep
Setia.
Initially, it was
One by some other, C. Jitendranath Chakraborty, is that it? The investigating officer, namely Sri Jitendranath Chakraborty, submitted a final report dated 18/9/2010, filed a closure report. Closure report dated 18/9/2010. Full stop. The learned thereafter, the learned special judge by order dated 4/8/2011 rejected such final report and directed the Superintendent of Police V&AC, Vigilance and Anti-Corruption, to reinvestigate the case and to submit a report within 3 months. Thereafter, the present petitioner was entrusted with the reinvestigation, and after completion of reinvestigation, he once again filed final closure report. Full stop. Thereafter, the learned special judge, after considering the material collected on the basis of material collected, came into a conclusion that there are disproportionate that the accused in the case acquired disproportionate asset, and therefore concluded that the present petitioner as IO, despite having sufficient material against the accused, instead of filing application for prosecution sanction to the competent authority, has filed the final report, and therefore he has committed offences under section 217, 218 and 219 of the IPC. The learned special judge just quoted the provision of section 217, 218 and 219 IPC and came to the following conclusion. Page 26. In the considered opinion of this court, though from the aforesaid quoted portion, in the considered opinion of this aforesaid opinion of this court, neither from the aforesaid quoted provision nor from the materials discussed by the learned special judge, even if it is taken at its face value and accepted to be correct, shall not make out any offences under section 217, 218 or 219 of the IPC. There is nothing to suggest that the petitioner has conducted himself in a manner intending to save the accused, except findings of the learned special judge, that too without any material suggesting such conduct. There is also nothing on record to suggest any ingredients, prima facie ingredients under section 218 IPC, or that the petitioner, being public servants, has corruptly or maliciously made certain maliciously made any report during any judicial proceeding. It was the opinion of the investigating officer on the material available on record that no case is made out. It is a different thing that the learned trial court may find some materials to take cognizance or to have a satisfaction that prima facie case is made out against the accused for proceeding with the trial, and it is a different thing that such final report is result of commission of any offense under section 217, 218 or 219. That being the position, in the considered opinion of this court, the no, Tarbulga. It is also submitted at the bar that subsequent to the impugn order dated 21/3/2013, another investigation was conducted and search sheet was filed. However, the main accused in the case has already been acquitted. Be that as it may, which is not subject matter of the present litigation. For the reasons recorded herein above, this court is of the view that this is a fit case where this court should exercise its power of under section 482 for quashing the impugn order dated 21/01/2013. Accordingly, the impugn order dated 21/01/2013 stands set aside and quashed so far relating to the lodging of complaint of the petitioners and the finding against the petitioners.
Consequently, the complaint case number 159.
Accordingly, the complaint case number 159 C 13 shall stands set aside and quashed. The LCR be returned back.
May I pray for some accommodation, my lord? If senior counsel appearing on behalf of my lord, respondent number 2 is out of station, my
Oh,
lord.
let him be. Forget about respondent number 2. You are here, that is enough for us.
And my lord, previous work with Mr. Alam, my lord, I got today, my lord. At least 2 days, day after tomorrow also I can proceed, my lord.
Where is the impugn order?
My lord, impugn order is, my lord, an except 2.
Heard. Yes,
My lord, it is a,
sanction is a must.
yes.
It was not taken, dismissed. Then how can the chief judicial magistrate once again take a complaint under 150/63 and that to send it to CID? So as the authority. Yes, you are for whom? Yes, Argo. You are allowing this petition. No time. Time, not granting a time is a foregone conclusion for these matters. That has already been notified in the cause list. What is the year of this? Which year?
2013.
2013. I feel bad, Mr. Saranya.
My lord.
If you say that respondent number 2 is not here, so therefore adjourned.
My lord, I call up him, my lord.
Why should you call him up? It is your case. You be prepared. You argue your case. What is your case? Is it the way?
Sorry, my lord. That attitude should not be from our
We
side.
are sitting here.
My lord, my lord.
We are doing our homework. We cannot allow to be so casual. Sorry. We have decided now these matters, fresh matters 19, 20, 21, we can accommodate. This is scar upon this system.
No sanction is required, my lord, 196. And that there is a double jeopardy once they have dismissed the petition.
Heard, Mr. Sir. Also learned counsel for the petitioner. Also heard Benchu, learned additional public prosecutor. And MS, we for the respondent number 2. The present application under section 482, read with section 397 and 401 of the Code of Criminal Procedure 1973 is filed for quashing the proceeding of CID PS case number 66/2012 under section 153A, section 505 within bracket 2/section 34 of IPC. Now pending, okay, full stop. The further challenge made in this petition is order dated 21/8/2012, passed by the learned Chief Judicial Magistrate, Kamrup, forwarding the complaint petition to the CID police station for registering a case and for investigation and to submit a report in final form. The brief facts leading to filing of the petition that on 22/6/2012, the respondent number 2 filed a complaint before the learned additional Chief Judicial Magistrate, Kamrup Metro, Guwahati, and the learned court, after on receipt of the said complaint, examined the complainant under section 200 of the Criminal Procedure Code and took cognizance of the offense under section 153A, read with section 34 of the Indian Penal Code against the present petitioners by an order dated 26/6/2012. And accordingly, summons were issued to the petitioners for appearance before the learned trial court on 31/07/2012. Thereafter, the petitioners appeared before the learned trial court through their counsel and filed an objection on 25/07/2012, praying for dismissal of the complaint petition and to recall order dated 26/06/2012 on the ground that cognizance on the ground that section 196 subsection 1 within bracket A of the CRPC 1973 bars cognizance of offense under section 153A of the IPC without previous sanction of central government or state government. However, no such sanction was there and complaint was registered. Thereafter, the learned court below, after hearing the parties, dismissed the said complaint by an order dated 18/8/2012 for want of prosecution sanction. The said order has attained finality in the meantime, and no challenge was made by the respondent number 2 to the said order. However, also, when thereafter, not when, thereafter, on 21/8/2012, the respondent number 2 again filed a complaint before the learned Chief Judicial Magistrate Kamrup Guwahati against the present petitioners with a prayer for issuance of a necessary direction to the CID police station to register a case against the petitioners under appropriate section of law and investigate the matter and submit a report to the learned court after observing all formalities as required under law. Accordingly, said complaint petition was registered as petition number 9509 dated 21/8/2012. The learned Chief Judicial Magistrate, under its order dated 21/8/2012, forwarded the said petition to the CID police station for registering a case and to do the necessary investigation and also to submit a report in final form. The aforesaid complaint petition as well as the order dated 21/8/2012 is under challenge in this present petition. Mr. Saranya, learned counsel, in the aforesaid backdrop, argues that once the first complaint was dismissed for all meaning and purport, the present petitioners were discharged from the for discharge from discharge, and therefore discharge, and therefore the subsequent complaint could not have been, and some subsequent petition could not have been entertained by the learned judicial magistrate, that too and could not have forwarded it to the CID police station in exercise of its power under section 156(3) of the CRPC. Inasmuch as such procedure has compelled the petitioner to face an unnecessary prosecution. And same will lead to double jeopardy. Yes, he further contends that even if the materials are taken on its face value, no case under section 153A is made out against the petitioner.
505 also.
Yes, what is yours then?
5052 also not.
150 and 5052 within bracket 2 of the petition. Yes, what is your case?
Lordship, as that democracy case made out.
And what about the discharge sanction? What about discharge and sanction?
Lordship, as we need to reconstruct the file, Your Lordship.
Par contra, learned counsel argues that the prima facie case is made out and the learned chief judicial magistrate has not committed any error so as to interfere with the same in exercise of power under section 482 CRPC, inasmuch as the learned chief judicial magistrate is within its competent to direct the complaint to the CID for registration and of an FIR. Full stop. When can you argue? Tomorrow?
Yes, Your Lordship.
Huh?
Yes, Your Lordship. Tomorrow we'll fix the date, Your Lordship. My senior will appear in this matter, Your Lordship. May kindly, Your Lordship.
Section 153A reads as follows. Just we'll write it down. Huh? We'll hear for 5 minutes tomorrow, if possible, and otherwise not. Not tomorrow, day after tomorrow. 215, huh? Quote it. IPC. 2, not 215. What do you say? 153A. Section 196(1) within bracket A of the Code of Criminal Procedure reads as follows. CRPC. Thus, from the aforesaid, it is clear that section 196 within bracket 1A bars taking cognizance of any offense punishable under chapter 6 or under section 153A of the IPC. IPC without the previous sanction of the central government or the state government or the district magistrate, as the case may be. Admittedly,
1A also, my lord.
1A.
1 also because of 5052.
1A. Okay, 5052. Huh? Therefore, 153 and 505 huh? Under 1A. Therefore, there is no doubt that a cognizance cannot be taken without sanction of the central government or the state government, and in the case in hand, without the state government. Therefore, and in the aforesaid backdrop, the first complaint where cognizance was taken was dismissed. It is also equally well settled that the creation of bar of taking cognizance as recorded herein above shall not automatically bar registration of an FIR or an investigation of a police authority, inasmuch as such bar is against taking cognizance without sanction, and the said provision shall not have a bar for continuing with the investigation without sanction. The bar is for taking cognizance and not for continuing investigation. Therefore, therefore, this court is having no hesitation in mind that an investigation under section 153A or 505 can be carried out there shall not be any bar for registration of a criminal case or investigation by police agency or submission of a report by police after completion of the investigation. However, in the given facts of the present case, the vital issue arises is whether in the given facts that already a complaint was dismissed on the same facts, the learned judicial magistrate would have entertained the subsequent application on the same facts and directed investigation by the CBI. At this stage, the learned counsel for the respondent press for some time to address on the aforesaid issue. You also. And at this stage, learned counsel for the petitioner as well as the learned counsel for the respondent press for some time to address on this issue. This is the issue. There is no bar. Court can very well send it if satisfied that other aspect will come, whether straight away 156, no FIR is registered, whether affidavit is there, not there, those things will come. Those things will come, but you cannot say that because of sanction, investigation cannot be carried out. There is a bar for cognizance, not for investigation.
For the TT Anthony, my lord. Second complaint or FIR is barred, my lord.
Now question TT Anthony judgment was passed when?
To my lord.
And where complaint is when? Can you say that it was, all these issues are there. So.
And Priyanka Srivastava also, my lord, that is there.
That we'll see. Yes, this is the issue. But your ground is only whether the second registration can be done. That's all.
And there is no.
So therefore, one part we have clarified that investigation can be done. Otherwise, if we say no investigation, it will be difficult. Yes, investigation cannot be done in certain cases under PC Act, in certain provisions, where first sanction is to be taken that whether we should register and we proceed with the investigation and inquiry.
Before proceeding.
Yes, not here. List this matter. How many matters will fix tomorrow? Today's list will go to tomorrow. When? Give a date. 12.
12, my lord, 13, my lord.
No.
Tuesday.
13th. 13th possible?
12, I have other matters.
Or 13th.
High level.
Everybody will have other matters. We'll not wait for anybody.
My lord, outside matter with something.
You keep your juniors ready. This is the high time.
My
Just tell your
Will be
senior,
prepared.
this is the issue.
Yes, your lordship.
high level.
At least our half work is done.
My lord.
Yes, what is your case?
My lord, this petition under section 482, my lord,
Hmm.
writing of FIR.
Crossing of FIR.
FIR, your lord.
What is the offense?
My lord, before that, may I submit in my lord, not say so that it will be easier, your lordship. My lord, the petitioners before your lordship, they are my lord the director and managing directors of Unichem Laboratories Limited, your lordship. Medicine company, my lord. They are engaged in the business of my lord manufacturing and supply of medicines, your lordship. Petitioner, my lord, engaged, my lord, complainant company, Candid Drugs, your lordship, for the purpose of supply of goods. And in the agreement, your lordship, commission agreement, it has been specifically mentioned that no third party rights shall be created by the Candid Drugs. My lord, during the course of my lord, that transaction and all, it has come to the notice of petitioner company that the respondent company is indulged in my lord, issuing my lord fake invoices, and around 10 crore rupees was my lord not paid to the petitioner company. When it was inquired, then one meeting was held, my lord, with the candidate also, that the representative who is the complainant before your lordship. In the minutes of meeting, my lord, that your lordship will see at page 61. It was admitted by that my lord, that there is a my lord liability of 10 crores rupees, and thereafter it was my lord undertaken that he will make the payment of my lord if some time is given to the complainant, but nothing has been done. Then petitioner company has issued notice to Candid Drugs, your lordship, legal notice for payment and all. Thereafter, my lord, payment was not made. Then an FIR was lodged at Mumbai, my lord. That your lordship will see at page 89, my lord. Against
What happened to that FIR?
my lord, still my lord, that 10 years, my lord, I have tried to inquire regarding the status, but in the meantime,
No, we'll go to the meantime.
my lord, civil suit was also filed and matter was referred to arbitration that they admitted in their complaint FIR itself, which is subject matter of today proceeding, your lordship. So in that FIR, your lordship, it was lodged on 7/12/2012. After approximately 1.5 years, your lordship, in that FIR, your lordship, SLP was also dismissed. He approached learned session judge Mumbai, bail was rejected. Then your lordship, Mumbai High Court also bail was rejected. Then SLP, it was also dismissed. Then after dismissal of SLP and all, your lordship, the present FIR has been filed, taking different stands, saying that my company has engaged their staff in preparing those fake invoices and all. And
now, where are the ingredients of 120B or
my lord,
424?
nothing, there is no allegation, my lord, individual allegation. No specific, vague allegations are there, your lordship. This is only to, my lord, settle that FIR and personal grudge. He has made party to the officers and employee of the company without making party to the company with whom he has entered into an agreement, your lordship. Ingredients of sections are also not attracted at all.
And as per he himself saying that a matter is referred to arbitrator, arbitration proceeding is going on. Simply he has written name, your lordship, page 136. Of managing, he has made party to all vice president, manager, general manager, deputy manager, ex-manager, everyone.
Yes.
Lordship, we have received information that respondent number 2, Lordship, just recently passed away a few months ago, which is why, Lordship, and respondent number 3 also, we have not been able to contact them. We are seeking some time.
That
to-
is between you and your client.
Otherwise, this case was not listed for a long time, so Lordship.
So is it? Who expired? If expired, expired.
Complainant.
Complaint expired is expired. It is to the advantage.
Lalita Kumari also not followed, my lord.
Yes, so as where are the ingredients?
Lordship, may I seek praise of for some time for preparation of this case?
We cannot make reference tenders. I have granted no adjournment to anybody. You have seen it from morning. Not a single adjournment. You stay?
My lord, this honorable court, my lord, granted that if charge sheet, I inquired, but no charge sheet, your lordship, but no cognizance shall be taken by magistrate. Order is there, your lordship. Order dated 17 February 2014.
Yes, when will be able to argue?
Any date next week, Lordship.
What happened to the suit?
My lord, in suit, my lord, matter was referred to arbitration.
And what about
Arbitration, my lord, I am also not updated, my lord. I tried to contact him yesterday, my lord. I will
find it out.
My lord, I will do, my lord.
Nothing is going to happen. These are the immediate jerk reactions. Now the burden is upon the court. You also don't have any instruction from your client.
Regarding
You are also not having any instruction. Only because this court is not granting adjournment, everybody is here. Isn't it? Yes, give a date. Mr. Bhattakur, go through it, argue it.
Yes, I'll
on the
go
basis of the
through it.
basis of the merit, whether case is made out
Okay,
and whether the connecting facts leads to a conclusion that it's an essentially a civil dispute.
Yes, Lord, that I will.
There's two issues will look into whether case is made out. Even in civil dispute, yes, there can be, but just reading the FIR, I am not getting anything to suggest
Criminal intent.
except this could have been a very good thing for filing a suit. Pleadings in a suit, it would have been better, but I don't
That
think
is
anything,
particular,
subject to
sure.
what you say. 14th. 14th, not 14th. Then next week. 18th, I am not here. No date on 18th.
Except
20
26, except 26. I
Except-
was waiting for that only.
Yes.
Except
27th.
27th, all right. Deeply.
Obliged.
On the prayer of the Mr. Bhattakur, learned counsel submits that he needs some instruction from his client in this matter. So accordingly, prays for an adjournment. Prayers then allowed. Please this matter. 27th. Yes. Yes, what is this?
But the other side is not present.
No, that we know. Are you aware what is the case? If not, then tell us. I am asking what is the case. You are saying other side is not present. That is not answer to my question. Are you aware what is the matter? If not, I will go through it.
Right?
You are not aware.
But in the complaint, otherwise, it is a civil in nature, but just
No, no. What is this application? 482.
yes, my lord.
Seeking what?
Taking quashing, my lord.
Quashing of?
Complaint as well as the court will take the revision.
Where is the complaint?
Complaint is page, my lord, 15.
Hmm?
Page 15, my lord. Page 16. My lord, the
None appears for the petitioner on call, though Mr. Swenchu, Learned Counsel, is present. Full stop. The present application under section 482 CRPC read with section 397 and section 401 of the Code of Criminal Procedure 1973 is filed seeking quashment of a complaint instituted by the respondent before the Learned Judicial Magistrate First Class Nagaon, which was registered as CR case number 1184/2013 under section 420, 406, 294/506/34 IPC, and also for quashing order dated 26/12/2013 passed by the Learned Judicial Magistrate First Class Nagaon and Nagaon. The fundamental ground as discernible from the statement made in the petition is that the matter is essentially a civil dispute, and that the alleged contract was awarded to the earlier principal who was suspended by the governing body resolution number 2 dated 19/10/2011. An inquiry committee was constituted to inquire into the matter, and it was found that no work was executed. The complaint is reproduced herein below. Where is the translated copy? From page 16, pencil mark to pencil mark. From the reading of the complaint, it is seen that the allegation is that the respondent / complainant executed a construction work, and construction work on the basis of a contract with the then principal of the college full stop. After completion of the work, bill was prepared by the complainant informant amounting to rupees 501140, and an amount of rupees 335,500 has already been received by the complainant, and the balance amount of rupees 165,500 remained due. Which was promised to be paid after completion of the work. According to the complainant, after completion of the work, do the complainant requested the member of the governing body to make payment of the said balance amount, but they did not pay any heed and in turn misappropriated the same. Full stop. It is further alleged that when the complainant demanded the amount and approached the accused abused the complainant with slang languages. Full stop. On the basis of what is the statement?
It's not here, madam.
Any record is here?
Record minute, page 20, madam.
Page
Page 20, 20.
20.
This one. The London magistrate, madam.
Okay. The complainant and one witness was examined under section 200, and on the basis of such statement, what is the statement?
The statement is not annexed here. Actually.
Oh, sorry. Please this matter before any other bench without me. Sorry that I have seen. List this, sorry, I have dictated so much. List this matter before any other bench without me. You are saved. Yes, Mr. Sayala.
So this is a matter of passing of a complaint under section 447, 427.
Item number
18.
18.
My lord, what happened, my lord? The civil suit was filed, decree was passed. The decree was executed on 19/5/2012. Your losses may come to page 11.
Page 11. Yes.
My lord, today on so and so, the possessor by Nipendra Mohan Das and Palachandra Das, with the help of police staff, Ramakrishna going to place of execution at Parana process with the help of Babu Ravidas, who is the inhabitant of Ramakrishna by his drum. And the matter of process was informed to a public officer identified by land. And after
You are Tila Babu.
My lord,
You are Tila Babu.
my lord, I am actually Tila Babu is my garden employee, my lord.
Okay.
Gardener.
Okay.
So in his position, my lord, he has taken the portion of the land on behalf of the garden.
Now where is the
Now,
FIR?
they filed a complaint which was forwarded to police. My lord, that your loss will find at page 15. Here they have, my lord, alleged that in page 16.
Who are the accused here? Amolendu Dasgupta.
Three persons are neither here nor there, my lord. The manager and other, my lord, the high-ranking officers were eligible.
Okay.
Now, in this matter, my lord, police investigated the matter and filed the final report. Page 18.
What is your system?
Page 18, my lord, final report is filed. I shall place this, my lord, at page 19.
Just page 18.
18, my lord. Page 19, my lord.
Page 18.
Yes, 18 is the final report. The statement is page 19. The brief of the case is that on 27/7/2012, this is a CR case wherein complainant Abdul Haq, son of so-and-so, alleged that on 19/5/2012, well, that is the date on which execution was taken out. At around 12:30 p.m.
Now final report is given. Now what happened here?
Final report, then again, my lord, they have filed a complaint.
Where is that?
My lord, that same thing, my lord, at page 20.
Page 20.
20. Same, my lord, exactly word by word same. Again.
Now here also cognizance taken.
Yes, now cognizance has been taken under section 447, 427. My lord, the order of 2013.
Yes.
Lord, can you see the schedule of the court land, my lord? Land, my lord, the page 10, my lord. This is the title execution case and
page
10, my lord. It is under DAG number, my lord, 70, my lord. Page 10.
Okay.
My lord,
Title execution.
Yes, ma'am. This was executed, my lord, And in, it was in Dag number 70, my lord.
Where do we get
Schedule,
that?
schedule 1, my
Bounded
lord.
by- Okay.
Description of the sweet land pertaining to the settlement Sarbit, Dag number 70, final question number so. Boundary, my lord. Next, my lord. Bounded by east, west, and south, the land of the plaintiffs under Kalinagar Tea Estate, corresponding to the settlement Sarbit, Dag number 70.
Now, where is your first complaint?
My lord, first complaint, my lord. Is it totally different land, my lord?
No, tell us the first complaint. What is your
First
complaint?
complaint, my lord, schedule is at page 17, my lord.
Page 17.
Yes, ma'am. It is under Dag number 5, my lord. My lord, the
Just a
boundary,
minute, just a minute. Then what is your allegation?
they have cut down, my lord, by rubber garden, my lord, and butternut trees and, my lord, banana trees, my lord. On the use of this execution case, my lord. My lord, the 8 bighas of land, my lord, have. When the final report was filed, my lord, we have again,
Now, when final report is filed, what have you done?
my lord, we have complained against the final report, my lord. That is, my lord, can you see page 20?
Naraji.
Yes, ma'am.
Where is that?
Page 21, my lord, last paragraph, my lord.
Now, what happened after Naraji?
The court has taken cognizance, my lord.
No, you have filed Naraji. What
Yes.
is the order on Naraji?
My lord, this is a separate complaint case, my lord.
No. Suppose there is a final report is submitted. What is the
Yes.
procedure? Somebody files a Naraji. Court will to be decided that whether Naraji is what are the materials and accept the final report or say that I know this is either I will say for further investigation or take cognizance.
My lord, take cognizance was taken, my lord. That is, my lord, telling.
Then where is the question of section 200? This is the procedure. What is the procedure?
Yes, my lord, they say after section 202 deposition, my lord, the cognizance was taken, my lord. My lord,
What happened to the final report? Where is the order that I have not accepted the final report?
that may be in record, my lord.
Record is here. See, with my limited knowledge, what I understand is, after investigation, police either can file a final report,
Yes, my lord.
final form, in the form of closure or in the form of search sheet.
Yes.
If closure is filed, then magistrate closure is filed. Before acceptance, magistrate will issue a notice to the informant
Yes, ma'am.
that this is the closure report given, please appear. Now, in that case, you may file a objection.
This is
Okay,
the-
on the basis of that objection, as well as material available on record, court may either accept or may proceed with, may accept or may direct for further investigation or may take cognizance.
My lord, it's
Now, is it, I do not know, is it the procedure that we will have to file? I think this is the procedure.
Yes.
Then where is the question of taking evidence under 200 again?
my lord, in CR case number 181, my lord. the
So do you want to say that GR case is accepted, but Naraji is taken as
Yes.
CR? Where is the provision of under CRPC?
the CR case was filed, my lord. After Naraji case was,
So there is a GR case
yes.
on a police investigation.
Yes.
Now, with my limited knowledge in criminal law, what I understand is either is to be accepted, rejected, you will have to be heard. Even if it is closure is accepted, the informant is to be heard.
Then, my lord,
You were issued notice. You have entered appearance, file an objection. Now court will have to pass an order on the basis of this. Where is that order?
that GR, my lord, it is earlier case, my lord, page 12.
Am I correct?
Yes, my lord. And no order has been passed.
Yes, what do you say? Is it not the procedure?
My lord, that is the procedure.
Huh?
That is the
My lord, earlier CR case, my lord, it may be seen, my lord. This was under GR number 1230 of 2012.
Where do you get
That
it?
is the record, my lord. Yeah. Finally, it is also profession. Complaint is heavy, my lord.
And no final report has been considered by the minister.
See, the first order says receive the complaint.
My lord, in the earlier.
Heard the complainant. It appears that the complainant had stated about lodging an FIR relating to the subject matter of the case with Ramakrishna Nagar Police Station. Therefore, call for the report from the Ramakrishna Nagar PS under so meaning thereby on the date of filing of the complaint, according to the complainant, an FIR was pending. So therefore, he called this fixing 28/12/2000 for report.
And charge sheet was submitted, final report was later on. 39.
Yeah.
Yes, that report was not there. All in the meantime, knowing fully well that already a FIR is pending. Court took cognizance on 11/30, examine the complainant. So they immediately approach and there was a stay. That is the matter. And that was final report was not part of this complaint
No.
case.
No
It is not that it was your Naraji petition. You are making a wrong statement.
My lord, I specifically stated, my lord, in CR, my lord, that is, my lord.
No, in CR you have stated already an FIR was registered.
No, my lord, this is against the against the FR, my lord, we have stated, my lord. Last paragraph, my lord. Page
Of complaint petition.
Yes, my lord. Page number 21 and then 20.
Page number?
Page number 21.
Yes, tell us.
In this respect, I lodged a complaint before the Honorable CGM Court and said, Honorable sent case SDJM, case number CP.
Where have you, where are you
Last
looking?
paragraph of page 21.
This is
Case was before the SDJM by case number CP 622/2012. Honorable SDJM sent the said case to the police investigation of Ramakrishna Nagar for investigation, but the officer in charge of Ramakrishna Nagar Police Station did not take evidence of my necessary witnesses nor investigated the case. The said case was registered by the in charge of the police station. Officer in charge of the said police station did not investigate my true case, being influenced by the
No, you have filed, you have stated that, but what we have understood is that before you receive the Naraji notice, you have filed a Naraji petition. Therefore, court has called her, this is something, please call her. At that point of time, there is no cause of action for filing the complaint. See, there was you have already lodged an FIR.
Yes, my lord.
Okay. FIR was registered, investigation was going on. You somehow could either learn that the final report has been submitted or you file a fresh CR case. Saying that I have filed this CR case because I am not happy with the final report. That you will have to file when notice is issued to you.
The final report is made on, my lord.
That is not there. Therefore, court calls. If you go through the record, please see. First order says, it appears that the complainant has stated about lodging an FIR relating to the subject matter of this case with Ramkrishnanagar police station. Therefore, call for a report from the police station. Now, before that report receives, section 200 statement is recorded. How it is permissible?
That, my lord, before, my lord, FR, my lord.
Please go to before FR because here there is court has called for the report. It is not a case that investigator has filed a closure report. You say that I'm not happy with that. Not too many words you have said that closure report is filed, but you say that I am not happy with that investigation. So court says, okay, if you are not happy, let me see whether any investigation is complete. Initial order was fine. With the no summon was issued. Court would have seen and could have said something, but the subsequent magistrate, without waiting for the report from the police, takes records statement under 200 and takes cognizance. Is it permissible? Please go through it.
The fact remains that, my lord,
Fact remains, no, what fact remains?
both the lands are different, my lord. And in the meantime, we have filed a compensation case, my lord. That was decreed in our favor, my lord, and that.
So what remains in this case then? It's a civil dispute then.
Normally criminal
criminal ingredients, we are not saying that there may not be, cannot be any criminal ingredients when claim and compensation are there. There may be,
yes,
but this is the way to proceed. Yes, go through it. Since we are prima facie against you,
yes,
so we should give you a chance. Please go through it and enlighten it. PP, please this matter when on the prayer of the learned additional public prosecutor who seeks some time to go through the record, matter stands adjourned and be listed on. Note 14th, Musumi, mark this date, 14th and 18th.
Hello.
25th. কিমান আছে আৰু এডমিশন কিমান আছে হিয়াৰিং না যাম এডমিশন কিমানটা আছে okay yes
But here I am for the respondent number 2.
okay what is the case here
Background of the case is this petitioner filed a proceeding under 125 CRPC claiming maintenance against the petitioner before your lordship. As however, when the proceeding was going on, the petitioner before your lordship filed a petition that DNA test to be done.
In 125 proceeding?
Yes, DNA test is to be done because I do not admit the paternity. That petitioner before your lordship claimed that I do not admit the paternity.
So therefore court rejected it.
Court rejected it.
So against that?
Against that.
None appears for the petitioner on call. None appears for the petitioner on call, though Mr. M.S. Sikh, learned counsel for the respondent is present. The present petition is filed under section 482 of the Code of Criminal Procedure. Code of Criminal Procedure, assailing an order dated 17/2/2014 passed in MR case number 404/2012, passed by the learned CGM Borpeta, by which the application for DNA test by the petitioner was
additional CGM.
additional CGM by the petitioner was rejected. The brief fact of the case is that the respondent number 2 filed an application on 6/8/2012 under section 125 CRPC seeking maintenance from the petitioner for her child born on 23/7/2017, alleging that the petitioner is the father of the child. It has been further alleged that it was further alleged in the aforesaid petition that the father of the petitioner assured that the petitioner would marry respondent after birth of the child. However, when the petitioner refused to accept her and marry the respondent, the maintenance application was filed. After receiving the notice from the learned court, the petitioner appeared before the court and filed an objection denying the allegations brought in the application, and further prayed for a DNA test for proving the paternity of the minor child. Inasmuch as it is the case of the petitioner that he had no relation with the respondent, nor he is aware with any respondent. Full stop. Subsequently, another application was filed on 18/9/2013, specifically seeking a DNA test for proving the claim of the respondent. Full stop.
Is that petition, my lord, my client filed objection?
An objection was filed by the respondent wife in the aforesaid petition. Relying on the decision of the Honorable Apex Court in Gautam Kundu versus State of West Bengal, reported in Monu/SC/0345/1993 and the decision of the Honorable Apex Court in Syed Muhammad Khos versus Norunnisa Begum and others, reported in Monu/F. This is Andhra Pradesh. Okay, forget about this. The learned trial court learned court concluded that this is not a fit case where a DNA test is required to be given. In as much as DNA test cannot be directed as a matter of routine. And the proof of non-access between the parties to marry during the relevant period shall only is only way to rebut the presumption. Full stop. What happened? Any maintenance granted in the meantime?
Yes, my lord, that order,
Where-
order
where-
itself, my lord.
where- huh?
DNA test rejected and maintenance was granted.
No, that is in view of taking collision. Where is that order of maintenance? No. First, as the party objected, DNA test the prior of party of rejecting is rejected.
My lord. And that will be, my lord.
Where is that maintenance?
My lord.
Maintenance order is not there. Impugn order, there is no maintenance.
No, my lord.
What happened thereafter?
My lord, your lordship was pleased to stay the proceeding, given me cost of rupees 6,000.
Hmm.
And for this about, my lord,
No instruction. What
10
happened?
10 years, my lord, 10 years, the proceeding is pending. Your lordship would be pleased to see the order dated 21/3/2014.
No, I've seen that.
Yes, ma'am. So the guard was granted cost of rupees 6,000. And till then, the operation of the impugn order dated so and so, pending in the court CGM Borbota, additional CGM Borbota shall remain stay. And for this 10 years.
It is the Honorable Apex Court. In the case of Gautam Kundu, laid down the following proposition of law. Impugn order to pencil to pencil. In the case in hand, the DNA matching is sought between the petitioner and the child. Petitioner and the child. In the aforesaid background, and in the given facts of the case, more particularly considering that it is a case of maintenance, the learned trial court refused to grant such permission. This court has not found any glaring illegality or irregularity in the aforesaid order, more particularly in a proceeding. In the given facts of the case that the proceeding was under section 125 CRPC. CRPC. CRPC, CRPC, 125 CRPC, no? 125 CRPC. In as much as in a proceeding, just a minute. in as much as the task of deciding the marital status or parenthood can be dealt by an appropriate forum such as civil courts or a criminal court, and it is not advisable to enter into such an roving and inquiry in a proceeding under maintenance in a proceeding under section 125 of CRPC. CRPC. In view of the aforesaid, it is also a settled proposition of law that until and unless there are irregularity, and failure of justice, this court generally should not exercise its power under section 482 in cases of maintenance under section 125 CRPC. That being the position, this court is not inclined to exercise its jurisdiction under section 482 CRPC. However, this order shall not be treated as an ascertainment of the dispute regarding parenthood between the petitioner and the child in question.
The
Interim order stands vacated. LCR is in no,
interim order date may be mentioned.
interim order dated
21/3/2014.
14 stands vacated.
Obliged.
20 and 23. 20, okay, 20. Any LCR in this case? None appears for the petitioner on call. List this matter on give a date 3rd week of November or 4th week of November. 28th of November 2024. Just a minute. Ms. B. Sharma, learned counsel, be engaged as an amicus in this court case. Here is nothing, you go through the record. FIR was filed, then search sheet is filed. At the time of framing of charges, he says I plead guilty. But there is nothing, I have not seen any material or any recorded statement. The magistrate, I think then at that point of time was executive magistrate, maybe, I do not know. Just recorded, he has pleaded guilty, then I have taken his 313 statement and he's convicted for fine and all. So just go through it. A copy of the records be furnished to MSB Sharma registry to list this case reflecting name of MSB Sharma. When any convenient date we are fixing it on? Huh?
May I please, Your Lordship? Yes. In both of the cases, my lord, I am appear on behalf of Mr. S. Sharma, a senior engaged counsel, Kedas, with some problem today, my lord. So
Lordship, here it's an quashing of FIR and a subsequent proceeding, but as from the record, I have not seen that there was no interim order.
Hmm.
Here it is still 2011 complaint.
Okay, on the prayer of the learned counsel for the petitioner, matter stands adjourned and will be listed on when?
next week, my lord.
Next week will be
28, Lordship.
28. With same date, okay?
My name may not be recorded because my lord, in petitioner sides, my name is there. my lord.
Okay, okay,
So
okay.
that is why I'm.
Okay,
my lord.
okay.
My lord.
On 28, the same date.
31 and 30.
Yes.
Related to NIX, my lord.
Mm.
Only one thing, my lord, lordship may come to page 17, my lord.
Mm.
Only one thing that, my lord, the return memo, my lord, which issued on 1/1/2010, my lord.
Mm.
The notice was issued on 1 February 2010, my lord.
How it was dealt by the learned trial court?
That plea was not taken before.
Then
the trial court.
what remains?
But, my lord, this is a documentary evidence, my lord. And even it is
Come prepared, not today, we are exhausted. We'll take this matter this week only, okay? Or maybe next week 12.
next week, my lord.
Next week is 12. 12, mostly possible. She's waiting from morning, yesterday also it was there.
There is order in the record wherein direction has been given to appear or surrender before the appropriate authority. But
That we
there
have
is no
seen.
instruction. Now he is coming to
My lord,
merit.
Even my lord, I have no contact, my lord, with this client, my lord. Even my lord, this case has been conducted by the Mr. P. Sharma. He expired, my lord. So, yesterday, after the matter was listed, my lord, I went this house, my lord, and somehow find this, locate this file, my lord. Case of the-
Anyway, we do not know anything.
My lord.
We'll just proceed on these matters. Okay, Muslim, can it be on 12 or 13th? 12 or 13th? 12.
If you please.
I just give a brief note who are the when dates are given, please,
Mine.
either of you, when complaint was filed, when notice was issued. We are under a limited jurisdiction. We cannot enter into all this factual explanation until and unless you can show this is perverse.
My.
Okay. I think number 25.
No hearing today. We have done our part. Or anybody interested? If anybody is interested, please come forward. I think we have how many matters?
Several matters are disposed.
And they will have to complete, na?
Fine.
I am dictating, then I'll have to correct, upload it. Many things are still remains. Any urgency, anybody's, all are outside. Is not it? Moment it is hard, there is a chance for again going inside. Isn't it? Huh? So therefore nobody is interested. But will be against your interest.
Especially in the hearing matter.
Yes.
Again, it is all pending.
All pending. At least now today something are done. No date, no date. No date. Huh? Due leftover, no date. Then again new matters will come.